Good evening. Captain Retired Matt Edwards here with a Observation Post weekly report. Now, as you might know, if you see this, and if you had read my report I put out this morning, I decided to try 8 o'clock in the evening instead of 10 o'clock in the morning. Now, I had set 10 o'clock in the morning just for my own, personal convenience. And I never thought about maybe I might get more viewers and be able to affect change better by having it at a later time when more people might be online. So I decided to try this out. So without further ado, let me go through the weekly report. And as I was just about to go live, I realized I had the wrong date put in there. I saw that because I copy and paste and then I delete last week's report before I put in this week's stuff, I forgot to change the date up on top. So I just did that. Anyway, the first point I said I was going to talk about was the Reimbursement Agreement. I was going to do a review on it. Now, I haven't sat down and did a written review, but there are several things that jump right to mind when I think about reimbursement agreements. Sometimes they're called condition of benefits agreements, and they might have different names besides those two I just mentioned. But what it is something that's unlawful. Why is it unlawful? Because it's not part of the contract. The contract is about the four corners of the paper that people agree to, they sign. That is what gets reviewed in a contract law dispute before a judge. And the condition of benefits agreement is after the contract, and basically it's them trying to say to you that you won't get this money unless you agree to these terms. Now, I'll give you an example in my case. I used to be a worker for CRA. That was my civilian job. And I also was a reservist. Now, because I had two different insurances when I became disabled, well, presumably I signed two condition of benefits agreement. Now, I ran into a huge problem with Manulife because they said to me when I was applying, they said, well, first of all, you're a reservist. And because you're a reservist, you had to be injured on duty or you don't get SISIP. Now, I told them to go to hell. I said, you can't have two different terms like that, one for a regular first person and one for a reservist. But they stuck to their guns. Now, another thing they said was that they said, well, we know that you're getting the Sun Life policy and you're getting about $3,300 a month, you told us. So our payment is $2,025, and if we subtract the $3,000, $3,300 you're getting from Sun Life, you won't get a payment. Now, I told them, if I didn't use the words fuck off, I told them to politely fuck off. I said, listen here, you dumb son of a bitches. I said I had an insurance policy through CRA covering my civilian salary. I had a policy of insurance covering my military salary. Neither policy integrated with the other one, and they only insure each other. If you take into account Sun Life and Sun Life decides they want to take you into account, then I end up with no fucking payment, you dumb son of a bitch. Never got me nowhere. So, of course, I went up the line, true to the Minister of National Defense, Peter MacKay, finally, before it got fixed. It never got fixed the way I wanted it to. They did a stopgap thing where they said, well, Sun Life started to pay it first. Well, we'll consider them to be the first payer, and therefore, we'll pay you the full amount. And I guess they left it unsaid that they expected me to tell Sun Life about it, which I didn't. It's none of Sun Life's business that I had SISIP, and I shouldn't have probably told SISIP about Sun Life because they're not related. However, what occurred to me and why I'm talking about it so much now, I'm pretty sure I wasn't as suspicious of these people at the time. Therefore, I think it's pretty good logic to assume that I signed a condition of benefits agreement for Sun Life in 2009. Now, I wasn't approved for SISIP until 2013, 4 years later. Now, if it came down to a dispute about which condition of benefits agreement would apply, because I'm sure they're similar, I'm sure the Sun Life one, if it's legal, would be held to be better than the Manulife one. But yet the Manulife people were the one who gave me the most fucking hassle. Now, that was all ad-lib. My points about the Condition of Benefits Agreement was the Sun Life versus Ryan, Nova Scotia Supreme Court, 2003, and the Nova Scotia Supreme Court Court of Appeal in 2005. And in both of those cases, the subrogation agreement, as it was called, was discussed. Now, they were talking about subrogation, which is the reason why we have clawbacks, and that's an equitable principle, which says that the person who is getting insured, the insurer steps into their shoes, and if they have a lawsuit or some other action available, they can do it in the person's name. Now that's where all this bullshit comes from. It has absolutely nothing with reimbursement, because that means that if you had a lawsuit against Joe, who ran into you and you became disabled, and you chose not to sue that person because, you know, he's your buddy or something, well, the insurance company could say, fuck you, we don't care if he's your buddy, we are going to get our money back from him and we're going to sue him for you. Now that's what subrogation is supposed to be. Now what these son of a bitch insurance companies and the government is doing is they have gone and expanded the idea to one that is similar to not exercising your right to get compensation. So there have been cases in the past where somebody who was injured on the job, and then they were entitled to workers' compensation. Then they never exercised that right because of some reason. Well, people would say, well, you didn't exercise your right to get this, and we could have saved money if you had got money from them. And that's where this idea of sitting on your rights came from. So I think it might be related to that. Okay. Now, point number 2, I said, was the 2003 Canadian Forces Ombudsman report. Now, in that report, which is the one that led to the Dennis Manuge class action, they showed the concern was about privacy. And they said veterans are concerned that the government is sharing information with Manulife without good reason. And then they brought up the Condition of Benefits Agreement, and then they said, well, there's no problem here because, you know, all the veterans who are getting the Pension Act pension and are getting SISIP, well, they gave Manulife the right to do it under the Privacy Act. They signed away their right to have personal information, confidential information. Now, what they ought to have done is said, well, does Manulife, a private company on paper, do they have any need to know anything about a disabled veteran? Because there's a section in the Pension Act, for example, that says the government, even if you get a court order, can refuse to give the information to somebody else unless the court order is about a criminal matter or it's about a Veterans Affairs appeal. Now, those are the only 2 court orders under the Pension Act that the government wrote a law to say that they would honor that court order. So you can't tell me that a person's consent under the Privacy Act, which is required under Section 5, brackets 1 of the Privacy Act, really matters in that situation. Because the Canadian Forces Ombudsman could have looked at this and said, why do they need to know about it? They can't take it because of the Pension Act Section 30. Pension Act Section 30 says that if you owe a debt, the veteran who's getting the Pension Act, if they owe a debt to somebody, nobody can touch it in law or equity, and therefore, you know, piss in the wind. You know, you're not supposed to be able to touch someone's compensation for a personal injury. Okay, the SISIP case. The judge in the Manuge Federal Court 2012 case said the defendant invokes the Condition of Benefits Agreement. And then he goes on to say, I don't put any weight to that because the veteran is required to sign that before they get any benefits. Now, reading between the lines, what he said was there was psychological duress on the veteran to sign it or they wouldn't get their payment. So because duress voids any such agreement that you think you made, the judge never came out and said it, but that was what he was talking about. You can't put a gun to someone's head, force them to do it, and then hold them responsible for whatever they did. That's the law. And the fourth point I'm making, because I don't want it to be too long, even if I did change my time, I'm hoping maybe I'll be shorter, because sometimes when I was in today, I was going an hour and a half, 2 hours. I'm going to try to be a bit quicker. The next one was a Canadian Bar Association paper put out in 2010. And they were looking at subrogation agreements, and they brought up the fact that if, according to their paper, their advice, and I posted this picture widely in the past, they said that we advise that you do not, if you work for an insurance company, that you do not require the insured person to sign a condition of benefits agreement, or if you're the insured person, that you do not sign a condition of benefits agreement, because A, there was no money pass hands consideration, so it's not legal anyway under contract law, and B, it would make the person making the person sign it more liable for punitive damages, because you're making someone sign something that you have no right to ask them for, because basically they're making your insurance conditional. You're not supposed to have conditional insurance. You're supposed to have, if the risk happens, you get the insurance you bought. That's the way it's supposed to work. Now, SISIP, income replacement benefit integration. I never wrote anything down, but I have this idea, and I'm telling you about it now, about why, they shouldn't be integrated at all, but they think that they should be integrated. So they designed the earnings loss benefit / income replacement benefit to mirror SISIP as much as possible. In my expert opinion, that is because they wanted to say you can only get one or the other. However, there are many problems with that. First of all, under the common law system, if you get injured and someone has to pay you something like tort damages, you are entitled to get your compensation to make you whole, plus your insurance payment because of the Bradburn Rule, which comes from 1875, where a person had in England a 31-pound insurance policy. After he became injured in some kind of railway accident, the railway company said, well, he's been made whole by his insurance policy. So because he has been made whole by his insurance policy, he has no damages that we have to reimburse him for. Rightfully so, the judge told them to fuck off. The person buys insurance for a rainy day. But the main thing that they said was that, there's two different fields of law here, even though if they didn't say it outright. They said that one is due to the injury that someone causes them, and therefore the person has a liability to pay them back for the injury they caused. But the insurance is paid in contract law because the person bought an insurance policy. Now, I've been reading a lot of law, and I'm not a lawyer, but I've been reading cases. Insurance or tort law, when someone wrongs you and you had to get paid back for the person who hurt you, and contract law never mix, usually. The reason is that, contract law is consensual. You sit down and you negotiate a contract with someone, and you know the person at least through the negotiations. Tort law, personal injury law, is about two strangers who come together and one harms the other person. There's no contract there. They just happen to have an unfortunate experience together. So therefore, if you look at one and then look at the other, the tort law is about the duty of care. Did the person who hurt the other person owe the person a duty of care? Now, if they owed him a duty of care and they breached that duty of care and they were negligent, then they have to repay the person for the damages they cause. But insurance is sold, indemnity insurance, compensation insurance is for like house and boat and fire and stuff like that you can put a value on. But if you have something like life or disability insurance, you don't know how much a person's life is worth. So therefore, it's sold as a non-indemnity or non-compensatory policy. And it's in the contract that a formula is put in there, some kind of amount that you agree to, and you get paid that according to the contract. And that's why it will never indemnify you or compensate you for anything, because it's non-indemnity by definition. So these assholes want to take your money, okay? So you have the insurance companies say, you know, this person got into an accident, they got all this lawsuit damages, and you know something, we got to pay them long-term disability, and we'd like to take that into account. So what they did was, starting in a case in 1984 called Gibson versus Sun Life, a Canada Revenue Agency employee was hurt in a car accident, and they got lawsuit damages. Now the Sun Life policy, which remember is Her Majesty the Queen for the CRA people, they wanted to take the insurance and the lawsuit damages into account. So the judge came up with a cock-a-fucking-mamie rule that, well, you know, they're getting partially indemnified for their salary. They're getting 70% of their salary according to the contract, so they're getting partially indemnified or partially compensated. So therefore, the insurance can take the lawsuit damages into account. Now, judge, I don't know who you are. I don't know if you're alive, but go fuck yourself. That is not how damages and long-term disability insurance works. You are not allowed to take the long-term disability into account. The judge can't look at this and say, you know, that Sun Life policy is indemnifying him for 70% of his loss of wages. So therefore, the person who put him in the wheelchair can save money by taking the Sun Life into account, because that's what would have happened if long-term disability is indemnifying you for anything, compensating you for anything. The person who actually would have to save is the person who put you in the goddamn wheelchair, which is totally absurd. So the thing is that case shouldn't have happened. Now, next case was, did I write that down? Anyway, so then in 2003, the case I was talking about, the Ryan versus Sun Life and the Sun Life versus Ryan cases came up. And then the Manuge case came up. And then the Butte Estate case came up. Now, there's a funny fact. In the Gibson and the Ryan cases, it was Canada Revenue Agency hiding behind, you know, Sun Life. But in the Butte Estate and the Manuge cases, Her Majesty the Queen stepped out into the front and said, I am the insurer. Now, you see, you can't have it both ways. See, all of the cases should have been like Sun Life, Great West Life, Manulife, and none of them should have involved the Queen, or vice versa. You can't have two separate lines of cases where the government gets to hide away in half of them, and in the other half, it is out in the open. So this is what I've been saying for all along. Like, we need the government to come clean. The government cannot try to say, for example, that we don't insure the policy when they've already been to court. In Dennis Manuge's case, they said that, you know, the Chief of Defense Staff, which is a government representative, is the underwriter. Now, an underwriter in insurance, they take the risk of profit or loss, because they underwrite the policy, and if you were underwriting the policy and you had a lot of claims, then you pay out more money than you took in premiums. But the government isn't named as the insurer in the goddamn contract. They say on paper that the Chief of Defense Staff and Manulife have entered into a contract. Now, I was reading through that case again about Sun Life versus Ryan, or Ryan versus Sun Life, and they said that Ms. Ryan is not a party to the contract. Funny thing, only those who are party to a contract can be sued or get sued. See? So some of these things seem so obvious to me, and I'm there scratching my head. How come this stuff is going on? Because how can you have different lines of cases where they rule this way on one and the other way on another one, when we're going to think they're crazy if they keep doing that? Because, I mean, you want to have consistency. Anyway, income replacement benefit as social assistance. Now, that leads into the conditional thing I was talking about before. Social assistance has a bunch of names. It could be welfare, dole, stuff like that. And usually it's when the government is giving you income support, they call it sometimes. Now, the income replacement benefit is supposed to be compensation for personal injury. Now, why do I say it? It's because they put it into the Act. They said in the Act that the government of Canada owed a debt to the soldier who was injured, and therefore they had to pay them back. Now, that's called compensation for personal injury. It's similar to workers' compensation. So, in workers' compensation, an injured civilian gave up the right to sue, which has a value, and they get administrative comprehensive compensation in lieu of the right to sue. Now, the government would like to claw back things. If you have other things, like a Madame Young, she had employment insurance. So VAC clawed back the value of her employment insurance and reduced their legal liability. The problem with that is that, well, it's against the law. The Employment Insurance Act, Section 42, forbids it. It's also against the common law because employment insurance is non-indemnity and contributory. So you cannot reduce your damages by taking into account something that is non-indemnity and contributory. That's the Bradburn rule again. You just can't do it. So employment insurance, however, they found out about the Veterans Affairs Income Replacement Benefit, and they wanted to take into account her indemnity for her military injury, which is worse, because the non-indemnity and contributory employment insurance wanted to take into account the indemnity insurance from Veterans Affairs. That's fucking crazy. You cannot, in any way, shape, or form, derive some kind of benefit from somebody else's suffering. That is the rule. Okay, it's Rittenberg, Alberta Queen's Bench, 1961. And another one from 1926 in Ontario. Hollister, I think. So you are not supposed to get some kind of windfall from somebody else's unfortunate experience. That is common sense, and it is also the common law. Anyway, my point about this is that sometimes people think that you're getting, and I see this all the time, they put it into the Veterans Affairs annual report or something, about how much money we paid out in income support. Now, listen, VAC, if anybody is watching this from Veterans Affairs, give it the fuck up. You're not paying income support to somebody who just happened to be disabled. You're paying compensation to someone who was healthy and fit before they became injured in the service of Canada. So go fuck yourself. Now, do up short videos on the issues I've tried to document, 3 to 5 minutes maximum. Now, I've started that. I've got 2 done so far, and I ought to probably do a couple a day because they're only 3 or 4 minutes long. But I get exasperated with all this stuff, and I try to forget about it sometimes. Now, I also have a thing called ADHD, Attention Deficit Hyperactive Disorder, and procrastination is a really big key point to that. From some of my readings about it in the past, you get a shot of adrenaline when you left things to the last minute, blah, blah, fucking blah. Regardless, I want to have something on the record in case the worst ever happens to me. I could have a stroke, I could die, I could get hit by a car, I don't know. Anything could happen, and I want these fuckers to get caught. It's one thing for me to put it out there in a letter or some kind of form of a document where I list off all the different things. I'm up to 121, and I've thought of 1 or 2 more to put on there. But unless somebody reads that report or views that report, and then they say, geez, I think he got a point, I'm whistling Dixie, okay? So my point about all of this stuff, the reason that I'm before you and you are stuck watching me, is the fear that these son of a bitches will get away with how they treat disabled veterans. They shouldn't do it, but they are doing it. Just like, and I couldn't resist getting a shot in against Vladimir fucking Putin, invading a sovereign nation and deciding that you will kill all those civilians in order for you to make that part of your fucking empire, you goddamn bastard. Anyway, veterans to discuss. I'm planning on doing up like a people that I've tried to help or looked at in the past and different issues that I tried to use as an example with them, and I'm not going to remember all of it offhand. But Stuart Murray, he's a reservist veteran like myself in Nova Scotia. Now, one thing about reservist veterans is that we don't usually get even as much as normal veterans get. Every Canadian Forces veteran who gets medical release will get the Service Income Support Insurance Plan unless you're a reservist. If you're a reservist, you had to go through an additional hoop to jump through. You had to prove that you were injured on duty. Now that has resulted in, according to the Office of the Veterans Ombudsman report that I read, instead of it being, say, 350 people on average a year that gets approved, only 20 to 30 with an average of 22 get approved per year. Now, I saw a story on different American talk show, whatever, Stephen Colbert or whatever, and you get the odd bit of news that comes up, and they were talking about for cannabis, the number of prosecutions in the States for people who are black is something like 300% higher than people who are white, who are just simply using cannabis, marijuana. Now, you see, that's a shocking statistic, and that's why I was bringing it up, is when you compare the number of regular force people that get SISIP automatically, compare that to the few people who get SISIP, they don't get it automatically, and I say something stinks. What they ought to do is treat everybody the same. Not that it would help. Because if you got SISIP automatically just like a regular force person, then Veterans Affairs would simply take it into account. So I wanted to get fixed, but they also had to fix the fact that SISIP and Veterans Affairs cannot integrate because they're different. Because one is an insurance that you bought, and one is compensation for injury. They're different, so they can't integrate them. Now, under the SISIP policy, you can't assign your right to get SISIP to somebody else in Section 30, I believe. So what makes them think that they can say nobody can touch us, you can't give away or sell your insurance policy, but then, they take the SISIP into account. So the government saves at your expense. So each one of these two groups, VAC and the Department of National Defense, they're looking out for themselves ahead of the disabled veteran. VAC don't want to pay. SISIP don't want to pay. VAC's way to avoid paying is to cite, after around the end of the Manuge case on the 18th of May 2012, a Director General of Policy stated that we are going to consider SISIP to be a prescribed payment to reduce the earnings loss benefit. Now, under the old system, the Pension Act was being used to claw back, reduce the payment under the SISIP policy. So the Department of National Defense was saving because the person was getting the Pension Act. So the Department of National Defense wanted to save in that case, and Veterans Affairs was paying first. Now, what's supposed to happen is you're supposed to get both payments. It might sound like, oh my God, you're getting too much money. But one, I'll use Dennis Manuge's class action as an example. So the Pension Act is paid in relation to the Pension Act. It's paid to compensate the veteran for their injury in service. The SISIP policy is paid in relation to the contract of insurance known as SISIP policy 901-102. So you have two different sources of payment for two different reasons. For the Pension Act, you gave up the right to sue in order to get a pension, just like workers' compensation. The right to sue was not given up for the right to get SISIP, or Dennis would have been thrown out of court right away, because they would have said, you gave up the right to sue, so therefore, get out of my courtroom. So the contract of SISIP doesn't bear a lawsuit. See? They're different. Now, there is a line of cases that go back to that one I mentioned from 1875, Bradburn versus Great Western Railway. But there's another one a year before Dennis's case, and that was called Soltz, British Columbia Court of Appeal, 2006. Her name was Nancy Wilson Soltz, and she was an Rcmp officer. She got harassed mercilessly because she was a woman, I think. She ended up getting disabled, and the government had to pay, the government of BC, not the federal government, $950,000 for causing her the loss of her career. Now, they had to discuss the different parts of benefits, alleged benefits that she got. I put the word alleged in, the judge didn't say it. Now, they said, well, the Canada Pension Plan disability she's getting, that's non-indemnity and contributory, so that cannot be used to reduce the province of BC's damages. They said the Great West Life policy that she got because she bought an insurance policy, and because of the Bradburn rule and the Sarvenas case in 2002, they said that's non-indemnity and contributory when we compare it to Canada Pension Plan disability. So that is off the table. You can't use her insurance that she got to reduce your damages. Now, the third one they were looking at was the Rcmp superannuation pension. That's almost the same as the Public Service and the Canadian Forces Superannuation Act pensions. So that was the sole issue that was litigated needlessly. Why was it litigated needlessly? Because that has been a long line of cases about pensions are similar to insurance, and therefore are non-indemnity and contributory, so therefore they cannot be used to reduce someone's damages, to make a person whole. Boatwarelli versus Flanagan, Ontario Court of Appeal, 1973, Bradburn versus Great Western Railway, 1875. There's a long list of cases that say you cannot take a person's property, and insurance is property, or pensions, which are also property. The victim's property cannot be used to lessen the damages. That's the rule. But you know what they did take into account? The Pension Act pension. Not only Canadian Forces veterans can get the Pension Act pension, but Rcmp veterans. And the judge said, we're going to take into account and look at your monthly payment, look at your lifetime here, how much it will be, we're going to estimate it, and then we're going to reduce your damages accordingly. Now, anybody who's been following my stuff knows that I like to meddle. I'm a busybody, I guess you could say. I called up her lawyer. I think I might have called her up. I said, listen, you might want to go back to court and try to get all of the damages for her, because Pension Act Section 30 says nobody can take it into account. Now, presumably the judge is a Canadian citizen, and as such he elected members of Parliament by vote, and they wrote laws, and Pension Act Section 30 is one of them. And that says in law or equity, the Pension Act cannot be touched. So instead of the judge allowing, the Pension Act to reduce the damages, actually I'm getting ahead of myself. What I said to the lawyer, Barry Carter, was I said, Pension Act Section 25 allows for the reduction of the pension if you get lawsuit damages for the same event that causes the injury that you get a pension. Then therefore the federal government can save by taking into account and breaking down the damages, which is paid as a lump sum, breaking it down monthly, and then reducing the pension by the monthly amount. And therefore, the judge erred, because federal law is more stronger than provincial law, and, the federal law should prevail. So instead of the province saving, Ottawa should have saved. Now, I said, Barry, you might say, what's the difference to your client? But you could argue to the court that it's not her fault that everybody missed the statutory law, which is required under Statutory Instruments Act Section 12. Judges are supposed to take judicial notice of all federal laws passed by our members of Parliament. So instead of the judge noticing that Pension Act Section 25 should have been invoked, it's not her fault. So in her case, they should say, well, let her have all of it. Don't give it to feds the break, and don't give the province the break. Let her have it all. Now, the other part I just mentioned was Pension Act Section 30, which I didn't talk to him about, which is perfectly valid. You cannot take any part of the Pension Act, either take it into account or send a bill to Veterans Affairs Canada, because of Pension Act Section 30. All Crown debt payments have that kind of protection. There's the Canadian Forces Superannuation Act, Section 83. There's the Public Service Superannuation Act, Section 11.2. 10.10, my mistake. 11.2 is the bridging bullshit. So all of the Old Age Security Act, Section 36, Employment Insurance Act, Section 42, all of these laws where a payment's coming from the government, nobody is allowed to intercept them. Now that means intercept them directly by sending them a bill, or indirectly by taking it into account. Now how can I state that I know that so factually? Well, I can refer you to two other cases that jump out. Marzetti versus Marzetti, 1994, Supreme Court of Canada. The guy who had gone bankrupt and owed money in family law. He had an Income Tax Act refund due to him. So there was a fight between the two agencies that wanted to get the money. He wasn't going to get the money, which is bullshit, because, well, I mean, if he went bankrupt, why should the trustee get it for the bankruptcy, or why should the ex get it and him not get it? Because the Crown said in the law that, nobody can intercept a Crown debt. If nobody can intercept it, they can all go fuck themselves. But the judge was looking at it, and they said, well, the Financial Administration Act is the first line of defense about people taking Crown debts, and nobody can go through the back door if the front door is locked. Now, what that meant was, if a law, such as Financial Administration Act Section 67, forbade the assignment of a Crown debt, then you can't try to find a way to go around that law. You're a fucking crook if you do so. Because Parliament wrote a law and you put your mind to going around it. You're nothing but a sleeveen if you do that. You should abide by the spirit and intent of the law, which says that the Crown debt that's payable to a person goes to that person and no one else. That's what they said in the Supreme Court of Canada, our highest court in the land. Who can argue with them? Now, a year after that case was cited in a Beattie versus Ladouceur, Ontario Superior Court, 1995 case, and a lady was owed $300,000 in support. She saw that the guy who left the country, her ex, had nothing in Canada except his Public Service Superannuation Act pension. So she appealed the court. She asked for a remedy in which they would take the pension and liquidate it and get her money. Well, the Attorney General of Canada intervened in that case, and they said, Judge, if you give us an order, the Government of Canada, to liquidate that pension, you are going to be giving us an order to violate the laws that we wrote, such as Section 10.10 of the Public Service Superannuation Act pension. Now, the judge didn't say, I agree with the lady. They agreed with the Attorney General's intervention. So they said that there are two lines of support, two lines of protection for any Crown debt payment. The first one is the general protection under the Financial Administration Act, Section 67. But they said if Parliament wants to put an exception to the rule, that's no one can touch the money, they have to put express laws in place in the law itself. Like Canadian Forces Superannuation Act, Section 83 has an express exception for the Garnishment, Attachment, and Pension Benefit Division Act. So that's a law that came into effect in 1982 for divorce, and that's the only legal exception to the payment going to the pensioner. So if someone gets divorced and someone goes to court, gets a court order, sends a court order to the Department of Justice, the Department of Justice sends it to the department that makes the pension payment then diverts the pension payment physically to the person who got the court order. That's the way it's supposed to work. Now, seeing I mentioned I can't help, I'll say what the problem is with SISIP clawbacks, like the Pension Act. Instead of going to court, saying to a judge, Your Honor, this disabled veteran's getting compensated too much. They're getting too much money. The Pension Act's paying them, and we're giving them their SISIP long-term disability insurance. So we would like a court order for us to send to the Veterans Affairs Department, and they will divert the Pension Act pension directly to us. They avoided all that. They simply said they were going to claw back the value of the Pension Act. Then they had the gall, I read in one place, to say, this Pension Act pension is tax-free and we only claw back the nominal value, so we're giving the veteran a favor. Fuckers. That was one thing they said at one point. I can't give it a reference. Don't come to mind right now. But the fact of the matter is, I'll tell you exactly what happened. Under the Pension Act, that section I said was 25, there is an express exception for something you bought for or paid for with your contributions or premiums. It says they are exempt from clawback under the Pension Act. So the Pension Act cannot legally take SISIP into account because it's bought in contract. You pay the premiums, you get the insurance. And they respected the Bradburn rule, and they put into the law a codification of the Bradburn rule, and they said anything that you bought and paid for, we will not take into account. Now that affected the Canada Pension Plan, that affected the Canadian Forces Pension, and that affected SISIP. All three of those are bought and paid for, and they are non-indemnity and contributory. Now, under the Veterans Wellbeing Act, which was originally called the Canadian Forces Veterans and Reestablishment and Compensation Act, CFMVRCA, big fucking mouthful, the Veterans Wellbeing Act changed that rule because some nitwit thought, well, the Pension Act is wrong. The Pension Act left those payments alone. Why are we making both of these payments? This is wrong. They're getting too much money. So they put into the law, if you get the Canadian Forces Pension, if you get the Canada Pension Plan, if you get some other payment, we're going to take it into account and reduce the government's legal liability for making you whole. Now, see, that's against the common law. They should know better. But obviously, all they have in mind is to save money at our expense. So this is crazy. They shouldn't be trying to save money unlawfully. If they have some way to lawfully save money, I'm all for it. But you cannot violate the statutory law, you cannot violate the common law, and you cannot violate things like public policy. Precedent and stuff. Anyway, carry on. Asked the Member of Parliament, I called last week, I want to talk to Seamus O'Regan or one of his delegates, but I'd prefer the Member of Parliament directly. Why haven't they done anything about all these things I've been telling them about? But in particular, I thought, well, I'll pick out one thing and get them to look into in detail. And Manulife said that I owed them $15,000. Now, I think it was about the Canada Pension Plan Disability. It was sent directly to me because I didn't sign the Reimbursement Agreement. It's called the Irrevocable Consent Form. Okay? So Sun Life sent me one in 2012. Now, they wanted me to sign an irrevocable consent form prior to my getting approved Canada Pension Plan. I applied 4 times. And the first time I applied was around the time I got out of CRA and the military officially, 2012. So when I applied, the doctor didn't fill out his part. I filled out my part, and I sent in my part, but he didn't send in his part, and then I got denied. I said to Canada Pension Plan people, I said, listen, they said, you got to make a new application. I said, that don't make sense. I said, if all you're missing is his paperwork, and I got mine sent in, you get after him, you get his stuff, and then you adjudicate the file. Oh, no. I had to do it their way, so I went and did it again, did up my part again, and he did up his part, was sent it in, and they denied me. Later, they asked me to apply again, Sun Life, not Manulife, so I applied the third time. Now, on the third time, they sent me back a letter, 26th of July, 2013. And they said, thank you for your application, but we note that you don't have the required contributions to qualify. You need 4 out of 6 years, and you don't meet that legal condition. But I didn't open that letter, see? I threw it in the corner, like many other people who deal with the government and this bullshit, brown envelope syndrome. I didn't want to read it, negative bullshit. Threw it in the corner, didn't open it. Not until 2016. Now, when I opened it in 2016, I had already been approved when I was forced into making a 4th application which should have been denied based on the same reasoning as the third application, but somehow they had approved me. Now, what was the benefit of getting approved for Canada Pension Plan on the fourth one when the third one told me categorically I couldn't get it? On the fourth one, when I got approved, well, it caused my Sun Life to go down, it caused my Manulife to go down, it caused my public service pension to go down, it caused my reserve force pension plan to go down. Now, all four of those government payments amounted to $1,150 more than what I was getting in Canada Pension Plan, or maybe it was $1,550. But I also got a bill from those agencies for the retroactive period, because the Canada Pension Plan disability pays up to 15 months usually, although I've seen at least one case where they gave more retroactivity. So in my case, I got $14,351 that was paid to me directly. Now, normally, remember I mentioned that form, the irrevocable consent form, normally I don't think people say, fuck that, I'm not signing that if I can't change my mind, which is what I said. So, like the condition of benefits agreement, they signed us because under duress, and therefore the money goes to Manulife. Now, if the money had went to Manulife, I wouldn't be getting a bill from them. See? But Sun Life also sent me an irrevocable consent form. So they can't send the money to two different places. See? Now, I got a bill from the public service pension for $9,800. Got a bill from the Canadian Forces Reserve Force Pension Plan for $909. I got a bill from Manulife for $15,000, and Sun Life, they cut me off, or actually they did an estimation of Canada Pension Plan disability starting in March of 2014. I wasn't approved till November of 2014, and they were taking the Canada Pension Plan into account before I was approved, which is that reimbursement, that part they're talking about, the duplication of payments, they're saying, the retroactivity. So altogether, I ended up owing, according to my calculations, $39,000 for the sake of getting $14,351. Now, nobody in their right mind would do such a thing. Why would you enter into some kind of contract where you say, okay, listen, you give me $1 and I'll give you $3? Tell me who would agree to that bullshit. So anyway, that gets worse, because I'll tell you, recently I figured it out. I said, you get this bridging bill, like I did, $909. But if I had signed the irrevocable consent form and the money had gone directly to Manulife, they would have been sending me a bill for $909 and the public service pension for $9,800 for money I never received nor enjoyed. You know something? They're going to be in for a world of hurt when they get sued on that. Because you can't say that someone owes you money because they got money when they didn't get the fucking money. See? But it gets worse. That's a horror story. Canada Pension Plan Disability sends a tax slip to the disabled person for the money that they pay to Manulife or Sun Life. You can't tax people on money they didn't get. What kind of fucking nitwit twit came up with that? Stupid fucking assholes. That's going to be a scandal. When this comes out, the fact that the government since 1993 has been sending money to insurance companies, but sending the tax bill to the disabled Canadian, you can't tell me that somebody is not going to be raising fucking hell about that. Now, I'm trying to rile people up to make the hell start rising, because they set up a system. They know about it. You can't say we didn't know this was happening. They set up the goddamn system. Anyway, let me see. My eyes are getting blurry, so I might call her quits soon. Discuss the SISIP cases, Manuge. I have a lot of problems with the Manuge case. I think the judge was out to fucking lunch, except in the verdict. He said that SISIP was an indemnity for your lost wages, when actually it's the opposite. The Pension Act is an indemnity for your inability to work. You get compensated for your economic loss under the Pension Act. That's the way it is. Now, in 1970 or 72, they brought in an exceptional incapacity allowance, and that is for pain and suffering under the Pension Act. But they limited it to only people who are 98%, 99%, and 100% disabled. That's the system. But he had it backwards. Now, if you have something in a case, you're a judge, your reasoning, your ratio decidendi, is supposed to match the verdict. If the verdict doesn't match the reasoning, the other party has a right to appeal, rightfully so, because the judge is a twit. The government never appealed because they would have lost anyway. You have the right to get an indemnity for your loss and a non-indemnity payment, and it doesn't violate any legal principles. So whether or not SISIP is the non-indemnity or indemnity payment, or the Pension Act is the non-indemnity payment or the indemnity payment, as long as they're both different, Dennis still wins. So the government never appealed. Why would you appeal if you'd still lose? Right? What's the good of getting the good judge to correct that if at the end of the day to match the ratio decidendi to the verdict, Dennis still wins? So you will be wasting the taxpayers' money to appeal it. I mean, they never came out and said it, but that's my take on it. Anyway, SISIP medicals. As my eyes are going, you're probably tired of watching me for Thursday evening. Let me know if you think Thursday evening is better than Thursday morning. SISIP medicals requested by Her Majesty the Queen through Manulife. Number 1, my SISIP medical mess. Now, back in 2011, when I was about to get medical release, okay, my immediate superior, the adjutant, arranged for my SISIP medical. Now, there's no such thing. I think it was his way to get a shot at me, because he and I were always into it. And he arranged for my SISIP medical at the government expense. I got paid to go do it. So I show up to the doctor's office on the base, and I go see the doctor, and the first thing out of his mouth is, "This is bullshit." Well, taken aback, I said, "Well, what are you talking about, Doc?" "I got a copy of that memo you sent to the case manager for the Army, Carol Steckler, and this is all bullshit." I said, "Listen, Doc, I didn't give it to her to give it to you. I gave it to her so they could try to fix things that I noticed that were going wrong during my medical release process. But I said, I'm here for get my long-term disability assessment done by you, and here you are getting on like this. Now, I can only assume that you're going to probably do up something negative, and I'm not going to get it." How fucking stupid was that? But I think the adjutant sent me to him knowing that the doctor, I got emails from the Privacy Act, and they were sending like innuendo. "Well, Doc, if you knew what I knew about this character, you'd see what we're talking about, how he's a bad egg or something." Like, you're not supposed to get yourself involved when you have no business getting involved with the medical release process. That's supposed to be a medical issue between the soldier and the doctor. Okay, number 2. I said, "Is this an annual application, even though the total disability certification is supposed to last until age 65? Okay? Now, most people on SISIP will get it for 24 months. At 24 months, they get the boot. Some veterans are considered totally disabled as per the SISIP policy after 24 months, and they're supposed to get it until age 65. Those people that are on it till age 65, they make you do, or they used to, maybe they don't now, but at one point they used to make you do an annual medical. Now, not too long ago, I figured out this is an annual application. Instead of you getting it from whatever age you are to age 65 as per the policy, they're making you go to the fucking doctor every year and hoping that you won't qualify. So they're making you apply every year for something that you should have until 65 without worry. See? Nuts. It's crazy. Now, going into this, I read a report by the Organization of Economic Cooperation and Development about Canadian long-term disability and other pensions, and they said that on average, Canadian people getting long-term disability insurance get it no more than 48 months. Okay? So the average in Canada is 48 months. SISIP does 24. But the average, or the maximum, usually is 48 months. Now, I'll tell you how this is really significant. In 2013, Veterans Affairs Ombudsman did an actuarial report about comparing the value of the Pension Act versus the new system. Under the new system, they said SISIP/earnings loss benefit to age 65. Now, that whole report is garbage, because if you only get it for 2 years instead of 30, how can they say that you got paid a couple of $1 million or something under the insurance policy? So the whole fucking report is shit. Garbage. Now, Veterans Affairs, for their part, they were doing up reports about the new Veterans Charter. And in one of the reports, they said, we don't understand how come we still got people under that for 2 years. How come they're still here? They're supposed to be off it by now. They bought into the bullshit that SISIP was for 24 months and that's it. And they thought that their claims experience would be the exact same thing. But the government isn't as bad as SISIP Manulife. So people ended up on the rehabilitation system, even though it's supposed to last no more than 24 months. People are in this stupid system longer, but according to the Canada Gazette from 2006, the way they set up the system was supposed to be, for 24 months, you'll be in rehabilitation. At the 24-month mark, they had to make a decision, are you totally and permanently incapacitated, which is the exact same thing as SISIP's totally disabled definition, and they were supposed to decide, are you going to get it till age 65? If so, and they were going to keep paying you, it's not because you're in rehabilitation that you're getting paid. Then you're getting compensated for the economic loss. So for the first 2 years, they said they're going to give it because you're in rehabilitation. But after 2 years, you get it until age 65 to compensate you for your injury. Now that's garbage, horseshit. You are not allowed to do that kind of shit. A lifetime injury is supposed to result in a lifetime payment. You can make a payment every month until you die. That's a lifetime payment. Or you can get a lump sum. You're alive when you get it. That's a lifetime payment too. And people might say, well, Matt, we'd rather have a monthly payment than a lump sum. But what does the common law do? You're walking down the sidewalk, you get hit by a car. You sue the driver, you win. You don't get a monthly payment. You get a lump sum which discharges the person who hurt you from any further liability. It's only the government that came up with this Pension Act pension to pay people, and workers' compensation is kind of related to that. So, in a 1978 Supreme Court of Canada case called Andrew v. Grand Toy, the Supreme Court of Canada brought it up, and they said that's not up to the courts to fix, but we recommend that, you come up, the government pass some law about monthly payments instead of a lump sum. But Veterans Affairs went in the opposite direction. Instead of going along with what the Supreme Court of Canada said in 1978 and leave the Pension Act there, which was paying a person monthly, they brought in a disability award to replace the Pension Act. And before people say, well, no, there's really a suite of benefits, bullshit. Here's what happened in 2006. They brought in the disability award to replace the Pension Act. They brought in earnings loss benefit to replace SISIP. They brought in a permanent impairment allowance to replace the exceptional incapacity allowance. That's the basics, okay? It was a one-for-one replacement. Only after people complained that all of a sudden they said, well, you can't just compare the disability award to the Pension Act because, The disability award is also paired with the earnings loss benefit and the permanent impairment allowance. See, that's garbage. None of that was in their plans. They wanted to do a 1-to-1 replacement. I think under the Harper government, they passed a 1-for-1 law type thing. When they're doing up something to replace something else, they can't change it from 1 to 1. I believe I saw that somewhere in the Canada Gazette. But, well, seeing I'm on that topic, that's the last point I'll make. The latest bullshit we had was the pension for life. Came in 2017, announced by my member of Parliament, Seamus O'Regan, who was then the Minister of Veterans Affairs. Oh, we're going to give you guys a pension for life that you've been asking for. So then they changed the name of everything. Listen, if you change the name of the earnings loss benefit to the income replacement benefit and nothing else changes, you didn't do anything different. Change the name of the disability award to the pain and suffering compensation, but it does the same thing. Nothing new. You change the name of the permanent impairment allowance first to the career impact allowance and then to the additional pain and suffering compensation. Now, along the way, you change the taxability status of it. You didn't do anything new, but I'll tell you what you did do. You saved money at the expense of the disabled veteran by eliminating the career impact allowance, which was brought in 2011 under the Conservative government, when they said, you know, anybody who's getting the permanent impairment allowance will now get an additional payment of $1,000 a month. Now, the permanent impairment allowance was $500, $1,000, and $1,500, 3 grades. But anybody who qualified for any of those 3 grades was then granted the permanent impairment allowance supplement, PIAS, and that was a flat $1,000, and it was for life. So that didn't sit very well with the Liberals, I guess, and they decided to get rid of a Conservative measure. And in 2019, the Parliamentary Budget Office put out a report talking about pension for life, and they said, you know, we do note that there's a veteran's going to lose about $300,000 over their life because of your elimination of the career impact allowance supplement. Now, remember, that used to be the permanent impairment allowance supplement, and I think that what they were doing was trying to save money. They renamed everything, and they eliminated one benefit. What was the point of that fucking mess? You can't say that you smashed together, like General Tendrick said at a town hall, you smashed together 6 different benefits. Well, if you changed the name on them and nothing else changed, you didn't smash nothing together. I don't like to be lied to. I don't think anybody likes to be lied to. So the thing is, all this bullshit, that's what it comes down to for me. Listen, you run into problems fiscally. Tell us you got problems. Admit that you're cutting things. And don't lie to us about giving us extra benefits. And we're answering, we listened to you, and we saw that you wanted a pension for life. So we're going to pay you a pension for life when all you did was change the name on the existing fucking programs. Now, that's what they did. Now, let me know, even if you don't do it now, make a comment later, but I think I'm going to call her quits. The eyes are going, and I'm getting a sore throat from talking. We need this to change. It's not going to change unless people, first of all, see that what I'm saying makes sense. I'm not going to get here, waste my time and your time spouting off gibberish. Okay? What I say is common fucking sense. If you don't get physically in your bank account or your hands the Canada Pension Plan Disability, then don't you dare send a bridging bill to the person who should have got the money from Canada Pension Plan, but the insurance company got it instead. But you, the government, sends the bill to the person as if they got it. I hope that's clear enough. And then to make matters worse, tax the person for money they never got. You get money, you could have a fight with the government about whether it should be taxed. Somebody else gets the money. There shouldn't be any debate at all about you getting taxed on money somebody else got. Anyway, you guys have a good weekend, and I'll see you next Thursday.